How should the court determine if a particular area of sidewalk is a traditional public forum? The courts have identified three categories of forums. First, traditional public forums. Second, designated public forums. And third, limited public or non-public forums. Limited public or non-public forums are created where the specific property is open for the limited use by certain groups or dedicated solely to the discussion of a specific subject. In these forums, the government may impose restrictions on speech that are reasonable and viewpoint neutral. Designated public forums are created when government property that has not traditionally been seen as a public forum is purposefully open to be used as such. Restrictions on speech in designated forums are subjected to the same strict scrutiny as traditional forums. So why the distinction between designated and traditional? Well, the designation can be taken away. Restrictions on speech are subject to strict scrutiny, but if the government wishes to no longer offer that property up to be used for public discussion, it generally may. Traditional public forums differ in their permanency. A traditional public forum is a place which, by long tradition or government fiat, has been devoted to assembly and debate. In its 2022 opinion on determining whether university sidewalks were traditional public forums, the Supreme Court nodded to Where the Sidewalk Ends by Shel Silverstein as a means of acknowledging the significance of sidewalks in our society. Shel just has a way of creeping in at the most random places, doesn't he? No, shh, go away. Well, that was distracting. Anyway,
public places historically associated with the free exercise of expressive activities, such as streets, sidewalks, and parks, are considered without more to be public forums. In such places, the government's ability to restrict expressive conduct is very limited.
What are some policy reasons behind the court's upholding of sidewalks as a traditional public forum? For starters, sidewalks are areas that traditionally have been held open to the public for expressive activity. The public nature of sidewalks is generally readily apparent, and citizens do not need permission to use them. Historically, they have been used for communicating thoughts between citizens and discussing public questions. Such communication of ideas between citizens has long been important to American society. One of the cornerstones of the American political system is the ability of the citizens to question their government officials. Opening public sidewalks to expressive conduct, whether it be political or not, preserves the idea that citizens can speak freely amongst one another without undue interference from their government.
In determining when a traditional public forum exists, courts consider overlapping factors, frequently deeming a factor dispositive. Some courts have instructed that in determining a particular area of property is a traditional public forum, courts must consider whether the area manifests physical characteristics suggesting that it is open for public passage, the traditional use of the property, and the objective use and purposes of the space.
One factor the court considers is the tradition of availability of the place for speech. Sidewalks and parks, the classic public forums, are regarded as having been long available for speech purposes. However, recently, the court has focused on whether the specific place was open to speech. In the United States versus Coquinda, members of a political advocacy group set up a table on a sidewalk near the entrance to a United States post office to solicit contributions sell books and subscriptions to the organization's newspaper, and distribute literature on a variety of political issues. The sidewalk is the sole means by which customers may travel from the parking lot to the post office building and lies entirely on Postal Service property. When respondents refused to leave the premises, they were arrested and subsequently convicted by a federal magistrate of violating a federal statute which prohibits solicitation on postal premises. The court upheld a restriction on solicitations on post office properties. The plurality of 4 justices concluded that a postal sidewalk does not have the characteristics of public sidewalks traditionally open to expressive activity. Justice O'Connor said that the postal sidewalk was constructed solely to provide for the passage of individuals engaged in postal business.
In the case of Powell v. Noble, the events leading up to the suit occurred as Powell traveled to the Iowa State Fairgrounds, seeking to share his religious message on a sidewalk outside of the event's paid admission area. Several officers requested that Powell vacate the fairgrounds. The next day, Powell returned to the fairgrounds to share his message on a different sidewalk outside of the paid admission area. He was once again asked to vacate the premises and also banned from the fair for its duration. The court discussed that while public sidewalks have often been treated as traditional public forums, publicly owned and operated property does not become a public forum simply because members of the public are permitted to come and go at will. The government, no less than a private owner of property, has the power to preserve the property under its control for the use to which it is lawfully dedicated.
A property is not deemed to be a public forum simply because it is owned by the government. However, there are particular areas of sidewalk the court has pointed out as traditional public forums. In Sidewalk v. Macomb County, a median in the road was seen as a traditional public forum because citizens had been using it to put up political signs and to set up nativity scenes. This became a traditional use of the property, making it a traditional public forum. Another particular place of sidewalk that is generally accepted to be a traditional public forum is sidewalk at intersections. In City of Lakewood v. Willis, the state had enacted a begging ordinance which prevented speech at freeway ramps and intersections. The Supreme Court pointed out that restricting speech at intersections is very different than restricting speech at freeway ramps. Intersections, the court said, are consistently held to be traditional public forums.
United States versus Grace. There is no doubt that as a general matter, peaceful picketing and leafleting are expressive activities involving speech protected by the First Amendment. It is also true that public places, historically associated with the free exercise of expressive activities such as streets, sidewalks, and parks, are considered, without more, to be public forums. The sidewalks comprising the outer boundaries of the court grounds are indistinguishable from any other sidewalks in Washington, D.C., and we can discern no reason why they should be treated any differently. Sidewalks, of course, are among those areas of public property that traditionally have been held open to the public for expressive activities and are clearly within those areas of public property that may be considered, generally without further inquiry, to be public forum property. In this respect, the present case differs from Greer against Spock. In Greer, the streets and sidewalks at issue were located within an enclosed military reservation, Fort Dix, New Jersey, and were thus separated from the streets and sidewalks of any municipality. That is not true of the sidewalks surrounding the court. There is no separation, no fence, and no indication whatever to persons stepping from the street to the curb and sidewalks that serve as the perimeter of the court grounds that they have entered some special type of enclave.
Limitations the government can place on the exercise of free speech in a traditional public forum include restrictions on time, place, and manner. In Renton v. Playtime Theaters, the Supreme Court upheld a zoning ordinance prohibiting adult motion picture theaters from locating within 1,000 feet of any residential zone, single or multiple family dwelling, church, park, or school. The ordinance was upheld, and the court ruled that content-neutral time, place, and manner regulations are acceptable so long as they are designed to serve a substantial governmental interest and do not unreasonably limit alternative avenues of communication.